This is Equity Trust versus Nickolich, and each side will have 15 minutes to present their argument. The appellant will have 15 minutes and may reserve up to 5, and the appellee obviously will just have the 15 minutes. I know this is not dealing with any criminal matters or anything, but I always still like to say no mentioning victims, no mentioning minors, just in case there's a minor lurking in this case that I don't know. All right. And so if you gentlemen are ready to proceed, we're ready to proceed. And would you let me know if you want to save 5 minutes for rebuttal or any amount of time for rebuttal?
Certainly. Your Honor, may it please the court, I'd like to reserve 5 minutes for rebuttal.
Thank you. You may begin.
Okay, Your Honor, this seems to be what at first glance would be a relatively straightforward foreclosure case. However, as in every case, the devil's in the details. And we are appealing the trial court's judgment, obviously granting summary judgment in favor of the plaintiff and the appellee here on 3 bases. And I guess, first of all, I should note that our third assignment of error, that the money judgment on the note was a nullity based off of the appellee's merit brief, that seems to be a moot issue. If they are not seeking a money judgment for the purposes of enforcing any deficiency, then yes, that third assignment of error would have been mooted. We would simply ask that when this case is ultimately resolved, there is some clarification from the trial court that there is not, in fact, a money judgment from which a deficiency judgment could follow. Having addressed that, the 2 remaining assignments of error are really very interrelated, and a brief factual recitation will probably help to clarify those issues. This is not your typical foreclosure case in that the subject property here was never transferred to my client. So this was a land contract with a promissory note as well. Those are the 2 governing documents between my clients and the entity that he was purchasing the property from, Harbor Portfolio Ventures. At the time that he executed the land contract to them and the promissory note, after that, there were a series of transfers in which the original owner of the property transferred the property itself via quitclaim deed through a chain of 4 or 5 different entities before they finally ended with the appellee, Equity Trust here. And there was a quitclaim deed to memorialize each transfer, and there was an assignment of the land contract to memorialize each transfer of that document. The problem in this case stems from the fact that the very first link in that chain, the transfer of the property from Harbor Portfolio, was done pursuant to a power of attorney. And that power of attorney was never recorded in the Summit County Recorder's Office. So pursuant to Revised Code Section 133704, this is a problem because the statute requires that that power of attorney be recorded prior to the quitclaim deed and the assignment of the land contract. And I'd like to note to the court from the outset here that this case is unique in that even if Mr. Nickolich were to win the lottery this evening and pay in full his obligation to Equity Trust, I'm not certain that Equity Trust would be able to convey marketable title to him due to that defect. And Equity Trust has acknowledged throughout the process that if there was any such power of attorney, they don't have it and they can't get it. And the evidence that they presented in support of summary judgment was essentially an argument that we don't have this specific power of attorney, but we do have 2 other powers of attorney for 2 different properties, which demonstrates that we know what the law was and we were probably trying to comply with it. And they asked the trial court to make the inference then that they had the legitimate authority, even though they had no power of attorney to back it up. And our argument is that this is problematic because, again, as a land contract, and I guess let me take a step back and clarify. The trial court based its decision primarily upon a line of cases, one of them from this court, saying that a borrower does not have standing to challenge an assignment of a mortgage. And the trial court cited to a case out of this court, Big Blue Capital, which is referenced in both of the parties' briefs, and it's cited to a case out of the 11th District and a case out of the 8th District. I think that all of those cases are distinguishable. Number one, because every single case involved a mortgage rather than a quitclaim deed and a land contract. And those cases that discuss 1337 generally talk about how the documents are valid between the parties that execute them, that the statute is intended to protect third parties. And in this case, Mr. Nickolich is precisely that third party. He thought that he was buying a house pursuant to a land contract, and the owner that he was dealing with subsequently sold it out from underneath him. He's the third party that the statute is intended to protect. And the court disregarded those arguments, essentially saying he didn't have standing even to raise them in the first place. And so our first assignment of error is that under these specific facts, this becomes a problem of due process. I'm not aware of any other circumstance, be it a criminal or a civil case, where the elements of the charge against the defendant or the action against the defendant are just presumed to be met, and the defendant has no opportunity whatsoever to challenge them. I think there are due process considerations involved there, and this court has agreed with me. In a footnote in the McFerrin case, which I mentioned in my brief, the court talks about the standing that exists for borrowers to challenge these issues. I filed a notice of supplemental authority earlier this morning to another court, another case from this court, the Harper case, where again,
Counsel, the court hasn't even seen that, and I don't know that Mr. Hill has seen that as well.
It was actually just filed prior to this appearance today. And the only reason that I mention it is that it calls into question.
Well, I know why you're mentioning it, because you want to further your argument. But all I'm saying is the court can accept it for filing, but you won't be able to argue it.
Okay, certainly. Well, and regardless, even disregarding that case, if we look at the McFerrin case, and if we look at the reasoning in the Big Blue Capital case out of this decision that the court cited in favor of its ruling, again, Big Blue Capital is distinguishable because it involves a mortgage. It doesn't involve a quitclaim deed. It involves a mortgage where the defendant in that foreclosure action wasn't even a party to the mortgage. So again, there is a clear distinction between that situation and the situation here. Big Blue also relied upon a case out of the 10th District, Whiteman, which the 10th District has overruled in George, which I cited to in my brief. The 10th District has now very clearly held that standing broadly exists to challenge these issues. And this court has at least inferred that in McFerrin. The case out of the 11th District, the Workman case, which was actually my case, is distinguishable for the same reason. Again, it involves a mortgage. The 8th District, the Unger case, there is lots of case law out of the 8th District saying that borrowers lack standing to challenge an assignment of mortgage. Again, to the extent that they're considering a mortgage, those cases are all distinguishable. And that really is the brunt of our appeal, and the sole argument on our appeal is that Revised Code Section 1337.04 was essentially nullified by the trial court in reaching the conclusion that they reached. If that statute does not apply under these facts, then it does not apply ever. And I don't know how we can say that we've had proper due process when the trial court decision has basically abrogated a statute, which is really the thrust of our due process argument. Another couple of
counsel,
yes, ma'am.
Counsel. So there's no argument that that your client is in default or anything. It's just a matter that due process was not rendered.
There is not. I mean, I don't want to mislead the court in any way, and that's typical in every foreclosure case. If the homeowners weren't struggling to make their mortgage payments, they wouldn't be in foreclosure. But that doesn't mean that plaintiff's burden of proof is lowered or eliminated entirely. Even if we accept the argument that the appellee advanced at the trial court, which was essentially that power of attorney is not necessary because we've produced two other powers of attorneys from two different transactions from which the court should infer that if we had them there, we probably had a power of attorney here as well. That argument is problematic for a lot of reasons, but I think the biggest two reasons being, number one, it's requiring the trial court to make an inference in favor of the appellee, which was the party moving for summary judgment. So that's directly in conflict with Rule 56. But number two, it's not even the most plausible inference. The most plausible inference to be drawn on those facts is that they knew what the law was, and they just didn't follow it in this particular case.
And counsel, you're at your rebuttal time at 5 minutes. Do you want to save that or proceed?
I will save my time, Your Honor. Thank you.
Thank you. Appellee?
Thank you, Your Honor. This is Attorney Ethan Hill for the Appellee Equity Trust. I think our response, our rebuttal to that is going to be, our response to defendants' brief and oral argument is going to be probably shorter than most of that you've heard here. As counsel has stated, the defendant was in default. There was a proper motion for summary judgment. The burden for summary judgment was held, as was found by the trial court. Besides the issue of a power of attorney being recorded prior to the quitclaim deed and the assignment of the land contract, there's really I don't think there's any other issues in this case. The defendant was in default. Plaintiff had met all its conditions precedent to move for default. The amount of the principal and the interest due was met. So in terms of all that, I think summary judgment was proper. Let me lead off by also saying that this was a land contract. So it's always per statute, it's always in rem. I think you can only get fair rental value for the time that somebody's in the property. But beyond that, these land contracts are in rem. Mr. Nickolich does not have, he only had an equitable interest in the property. He had no legal interest in the property. Legal interest would not vest in the property until the executory contract, the land contract, was completed upon its terms. So Mr. Nickolich had no vested interest in the property besides an equitable interest that would only vest upon the completion. So as far as Mr. Nickolich arguing that that he has, a mortgage interest, this isn't a mortgage. He's correct about that. This is a land contract, and had this contract been for less than 5 years and less than 20% of the value of the purchase price of the property, we wouldn't even be in the trial court arguing for foreclosure. We would have simply forfeited the land contract. I think that we have proven our burden. I think that we have shown through the Big Blue Capital Partners that this court has previously ruled that a non-party to an instrument or a mortgage lacks the authority, lacks standing to challenge the validity of those instruments. We have shown through our briefing that, the Ohio Supreme Court and and this court have shown that, you know, the purpose of the recording statute wasn't instituted to be used as a defense by a party being foreclosed or being, you know, having a land contract being forfeited against them, but it was meant to be used for the protection of third parties who would potentially encumber some interest in a real property. This would allow them to know and understand, you know, the cost benefits of encumbering or transferring or somehow relating to that property. And I don't think the intention, as this court has implied, was to allow, you know, a defendant who is in default, whose equitable interest is attempting to be extinguished, to use that to get out of, you know, their debt, basically.
Counsel, that's what I was going to say, though. He's actually contending he is a third party that benefits from it, and therefore that's why the power of attorney needed to be recorded.
Well, I don't think he was a third party, because at the end of the day, Your Honor, he would have to. My client would have had, if he had completed the contract, my client would have had to deliver title to the property, or there would have been a cause of action against them. And so they would have been able to done whatever they needed to do to fix whatever defects in title at that time. Additionally, I lost my train of thought, but that's okay.
That's okay. All right. Is that any other questions from the panel?
Does the lack of the filing of the POA affect future transfers? You know, does it create a cloud on the title of this property?
It could potentially create a cloud on title, Your Honor. I think that that wouldn't really relate to Mr. Nickolich, however. I mean, if there's any cloud on title, that would relate to my client's interest in the property, and they would have to fix that at some later date. Like I said, Mr. Nickolich only had an equitable interest in the property. He didn't have a vested interest. And as I said, if he eventually had completed the land contract, my client would have had to fix that at some point. And this current action that we have, the forfeiture of the land contract, for example, if Mr. Nickolich was correct and the POA was fraudulent and my client was completely fraudulently transferring this property and, you know, fraudulently transferring the property, well, then the original transfer or harbor portfolio would also have an action against my client. So I think I don't really understand where Mr. Nickolich, besides losing the property itself, Mr. Nickolich, and that was as a result of his own default, nothing would end up coming back on Mr. Nickolich. You know, the parties involved would all look to my client, you know, for any defects in title or fraudulent activity.
Thank you. Thank you for your argument this morning.
Thank you.
And you have 5 minutes remaining for the appellant.
Thank you, Your Honor. I may not take that much time unless there are questions. First of all, as to the appellee's points that and I don't know if I should go so far as to say that he's conceding that there is a title defect, but it certainly sounds that way. And if this court agrees with me, then the obvious question becomes, if there is a defect in the transfer of title that exists right now, how did they have standing to file this case in the first place? And that's the threshold question. Before we even get into issues of default or amount due, if they didn't have the right to bring the action. Yes, Your Honor.
I'm sorry, I apologize. Well, I think another question, though, is how does your guy have standing? I mean, because yes, let's say that there is. I'm not saying there is or there isn't. But the point is, how does he have standing to raise the issue before us even?
Well, he is standing through the recorded land contract that arguably has never been properly connected to the appellee, to the plaintiff, but it certainly is connected to him. He doesn't deny the existence of the land contract or the validity of the land contract. The only question is the authority of the entity suing him to enforce that contract, and whether that entity could meet its own obligations. Again, to answer Judge Teodosio's question, and I hope I didn't just mispronounce your last name, Your Honor. Yes, I think we have a big title problem here. If my client were to simply abandon the house, I don't know that the FLE could sell the house and have a title insurance company issue a policy of title insurance in the absence of evidence that the 133704 had been complied with. Certainly, if the FLE were to just walk away, my client still has only equitable, not a legal interest in the property that he made payments on for several years. And he couldn't get insurable title if he wanted to sell his property as well. I mean, regardless of the outcome here, if the trial court, if you agree with me and remand this case to the trial court and the action is ultimately dismissed based off of a question of the standing of the plaintiff, my client still, that doesn't resolve his problem. His next step, we're thinking, would be a quiet title action against equity or the original entity in this chain. That's important to remember, because in foreclosure cases, there is always the struggle that how can it be equitable if someone defaults on their payments that the creditor is not entitled to their remedy? But in this particular case, there's a question of, is this even the proper creditor? Presumptively, these transfers from the original owner down to the current plaintiff appellee, in each transfer, I'm sure there was some consideration. They weren't done for free. And each of these entities that took title to the property did so via a quitclaim deed. So they understood that there were no warranties as to what they were getting. And in those circumstances, I think that compliance with 133704 becomes even more important. If there's an action that exists here, if there is a remedy for Equity Trust Company, I suggest that remedy would be to go back up the chain of prior owners of the property until they fix that defect at the first link. And then they could either bring a new action against Mr. Nickolich or take the results of that action against Harbor Portfolio.
Okay, thank you very much for your argument this morning, and thank you both. We will issue a written opinion after we take the matter under advisement, and also it will be sent to you. Also, we release on the Supreme Court website. So thank you, gentlemen. I hope you both have a wonderful day.
Thank you very much.
Thank you.